back to the podcast, everyone. I'm Candace.
And I'm Mike. Today we're doing a deep dive into the second part of the boring stuff that keeps us out of jail and our licenses intact. We're talking about the 2025 Professional Land Surveyors Act. This is part 2 of our podcast. Be sure to look for part 1 in the description below. It does not matter what order you watch them in, so feel free to watch this one first if you like.
Boring. Mike, this is the backbone of our practice. We're covering everything from the contracts you sign to the actual ink you use on your maps. If you're a surveyor or a pre-82 civil engineer in California, you're going to want to pay attention to these changes.
All right, point taken. Let's start with Section 8759, Written Contracts. Candace, I remember the days when a handshake and a beer were enough to start a boundary survey.
Well, those days are long gone. The law is very clear now. You must use a written contract before you even think about loading the total station into the truck. It has to be executed by you and the client or their representative prior to starting.
Unless the client knowingly states in writing that you can start early, right? But even then, you need that contract, and it can't just be a one-pager. The Act lists 6 specific things that must be in there.
Exactly. Let's list them for the folks listening. 1. A description of services. 2. The basis of compensation and the method of payment. Don't just say it'll be a few grand, Mike.
Chuckles. Fair. 3. Your name, address, and license number, plus the client's info. 4. How you're going to handle additional services. We all know scope creep is real.
5. The procedure for termination. And 6. This is a big one. Disclosure of whether you carry professional liability insurance. You have to tell the client if you're covered.
Now, I know some of you are thinking, do I need this for every little job? Section 8759.b gives us some exemptions. You don't need the formal contract if you're working for free, pro bono work, or if you have a prior relationship where the client has already paid you in full for past work.
Also, if you're working for other pros, if your client is a licensed engineer, another land surveyor, an architect, a contractor, or even a geologist, the strict contract requirements are relaxed. Same goes for public agencies or large industrial corporations like mining or utility companies.
And just a quick tech update, Section 8759.c confirms that an electronic contract is totally valid, so get those digital signatures ready.
Moving on to Section 8760, the power of the oath. Mike, do you ever feel like a judge when you're out in the field?
Only when I'm wearing the vest. But seriously, the law says we can administer and certify oaths. This isn't just for show, it's for when we need testimony to identify old or obliterated corners, or if we find a monument that's perishable, basically falling apart, and we need to record evidence about it before it disappears.
Just remember, if you do take an oath from someone, it has to be part of your field notes and mentioned on the record of survey. It's all about the paper trail.
Speaking of paper, let's talk about Section 8761, signing and sealing. This is where the rubber meets the road.
Everything you produce, maps, plats, reports, has to be prepared by you or under your responsible charge and must have your name and license number.
I see a lot of people getting tripped up on interim documents. If you're sending a draft to your client, the law says you must include a notation like preliminary or for examination only.
Exactly. And once it's final, signature, seal, and the date of signing. If it's a multi-page report, you've got to hit the title sheet or the signature sheet at a minimum.
And don't even think about using your seal if your license is expired or revoked. That's Section 8761.f, and it's a quick way to lose your career forever.
Section 8761.2 is actually one of my favorite parts of the Act. It's a liability shield. It says that if we sign a map, we aren't responsible for damages caused by subsequent changes made by someone else, including government agencies, unless we authorized those changes.
That's huge. If the city takes your map and tweaks a line without telling you, they're on the hook, not you.
Now let's get into the meat and potatoes of the Act. Section 8762, the record of survey. Mike, when do we actually have to file?
This is the million-dollar question. Generally, you may file any survey, but Section 8762.b tells us when we shall file. There are 5 triggers.
Let's run through them. 1. You find material evidence of a physical change that isn't on a previous map. 2. You find a material discrepancy, meaning the math or the positions on the ground don't match the old records.
3. You find evidence that might result in materially alternate positions of lines, basically if there's a valid argument for the line being in a different place. 4. You're establishing a line or point that wasn't shown on a previous map and isn't ascertainable from an inspection of that map.
And 5. You're setting points for a parcel described in a deed, but those points aren't on a recorded map. If any of those happen, you have 90 days to file.
90 days from the time you set the monuments or finish the survey, whichever comes first.
What if 90 days isn't enough? Maybe the client is slow or the weather is a nightmare.
Section 8762.d has your back. You can get an extension, but you have to write a letter to the county surveyor before the 90 days are up.
You have to explain why you're delayed and give an estimated completion date. You don't have to give all the survey details yet, but you have to give them the location and the APN.
And if you're the one filing, don't forget Section 8762.f. If you provide a postage-paid envelope, the county recorder has to send you the filing data, the book and page number, within 10 days of the final filing. It's like a read receipt for land records.
Let's talk about the physical map itself for a second. Section 8763. We're getting technical. 18 by 26 inches.
Or 46 by 66 millimeters for our metric friends. It has to be on tracing cloth or polyester base film, black ink, 1-inch margin all around.
And Section 8764 tells us what goes inside those margins. You need your found monuments, set monuments, their size, their kind. You need the basis of bearings, the north arrow, the scale, and the legal designation of the property.
You also need a memorandum of any oaths we talked about earlier and the formal statements from Section 8764.5.
Ah, the statement boxes. The surveyor's statement saying you did the work, the county surveyor's statement saying they checked it, and the recorder's statement. You can't put any other statements on the map unless the act requires them.
Wait, are there times we don't need a record of survey?
Yep. Section 8765. If a public officer already filed a reproducible copy, or if it's a BLM survey, or if it's part of a subdivision map act recording. Also, if you're just retracing a line and you don't find any material discrepancies, and you find enough monuments to prove the corner, you might just need a corner record instead.
And don't forget the interior lots of mobile home parks. That's a specific exemption under 8765.e.
Once you turn that map in, the county surveyor has 20 working days to examine it. That's Section 8766. They're checking your math and making sure you followed the rules.
But they can't make you change your field procedures. Section 8766.b is clear. The examination isn't a license for them to tell you how to do your job. They just check the result.
And they can charge you for the privilege. Section 8766.5 says the fee is usually capped at $100 unless the Board of Supervisors passes an ordinance saying it actually costs more to do the review.
What happens if you and the county surveyor just don't agree? You say the line is here, they say it's there.
Section 8767 and 8768 handled the fight. If they find errors, they send it back. You have 60 days to make the changes or disagree. If you still can't agree after 10 working days, you both have to note your differences on the map.
I've seen some of those maps. They get messy, but the law says the county recorder must file it anyway, even with the disagreement noted. It's about getting the information into the public record.
And if the county surveyor is just sitting on your map and refuses to act, that's Section 8768.5. You can take them to court, a ministerial action under Section 1085 of the Code of Civil Procedure. If you win, the court can even make the county pay your attorney's fees.
Wow, they really don't want these maps getting stuck in a drawer.
Precisely. It's all about the integrity of the land boundary system, whether it's Section 8762.5 requiring a certificate of compliance for land divisions, or Section 8763 mandating the specific ink. The goal is a permanent public record.
Well, I think that covers the bulk of Article 5. My head is spinning a bit with all those section numbers, but it's clear. Document everything, communicate with your client, and file your maps on time.
And and keep your seal clean.
Always. Thanks for joining us for this deep dive into the Professional Land Surveyors Act.
We'll see you in the next episode, Part 3, where we talk more about the Land Surveyors Act.
Thanks for listening. Signing off for now, please join us for the next one and be sure to subscribe and hit the like button. You do not want to miss any new content on land surveying.
Until next time.